Hey guys, Anthony Bandiero here, attorney and senior legal instructor for Blue Gold Law Enforcement, bringing another Search and Seizure show, and I'm joined by my fabulous co-host, Mike Boone. How you doing, Mike?
I'm great. How are you guys doing?
Now you're in Las Vegas. You're at Blue to Gold headquarters, our very advanced studio, green room.
Without a doubt, my friend.
Yep. And now I'm in actually beautiful West Memphis, Arkansas. And when I say the word beautiful, I don't mean any of it. I'm totally joking. This is, I think I almost got shanked twice going to my car, my rental car. But even though this is a very high crime area and a lot of unprovoked flights are occurring in the area, I think I'm about to run. I think I'm about to run in just because I'm scared. But the thing is, I will tell you, the cops here are off the hook, Mike. They are some of the best cops I've ever met. And I think you can understand why. I mean, it's just great, just great cops trying. I mean, especially when you work in areas like this,
You're working for
and
me.
you're yeah, and you're pushing that black and white. You're trying to really make a real difference. So I'm in Arkansas. Mike is in Las Vegas. Let's get down to this. So for those
Okay.
who are watching this online, who are watching who are watching or listening, I should say, on Spotify and so forth. We do have a live audience here. This is we're gonna what's up, Rick? We're gonna be
You cut out just for a second a minute ago, but you're good now.
oh, so he says I have a bad connection. Oh, I see. I know what the problem is. I know what the problem is. All right. I was my Google Drive was upload my Google Drive was like syncing and I have a lot to sync. So it was just kind of Rick, is that better? Do you want me to change it to locally or are we good? So
So you're
all
saying
right,
you're
well,
in sync?
yeah, look, I turned it off, so we're good to go. Okay. Yeah, actually last night we're doing a search and seizure for last night. Mike, the tornado horns went off.
Oh,
You're
that's
from Missouri. You know what those are.
I do. Yes, and I will be living them again here soon.
Yeah, you're going back to Missouri.
Yeah, they're
Okay.
interesting. A little bit unsettling, aren't they?
Yep. All right. So, Mike, brave. Okay, you got to be brave to take Brave's questions
Oh
because,
boy. I
yeah.
think
I'm gonna,
we should ask him.
no kidding. Let's get Mike Brave on real quick. But Mike, I want to Mike, do me a favor. Please keep it short and sweet. And this is for everybody. This is not just for Mike. Short and sweet because we really have a lot of questions to get through. Mike, you got a haircut.
Me or that one?
Well, Mike Brave, look at the hair. Look,
Looks nice.
what's up, Mike?
You should be able to hear me. Great day.
Loud and clear. Great day, my friend.
Uh, I,
Mhm.
I said, I'm giving you two comments. One of them's a gift. Very short version. Number one, the IMLA, International Municipal Lawyer Association, had a webinar meeting today on try to help officers understand what they could do in dealing with immigration enforcement, ICE, and when they're in different states that have prohibitions on it. And I
Right.
thought that would be absolutely perfect for you guys to do on a webinar. And therefore, I sent you. So that's the idea. Now, the
Yeah.
second part of this
Awesome.
is
Yep.
on Monday of this week, the IACP sent out two things. Number one, information on this exact same topic, which I emailed to four of you. And number
Okay.
two, they also sent out fact sheets on standards of use of force and qualified immunity, which are, in my opinion, are riddled with errors. So I just wanted to bring that to your attention. Go on with your day. Have a great day. But I thought you guys would be the absolute perfect people to guide people on what they can do with dealing with immigration enforcement and stay within the bounds of both state and federal law. That's it.
I love it. And you said you sent me an email on this, so I look forward to seeing that. As I always, always do your emails.
I also sent it to John, Zach, and I also just forwarded it to Mike as well.
Okay, man, you're the man. Thank
Thanks,
you so
Mike.
much. He's awesome. Man, well, shit,
Appreciate
that was
that.
easy. I get a little nervous when Mike shows up. He's like,
So-
"So what case with the
He's just giving
qualified
us a-
immunity did the court say X?"
Man, yeah. I love
Yeah.
Mike Brave.
That was a close one. You know what I
Yeah,
mean?
yeah, we're good. Ooh, all right.
For those who are watching on YouTube and don't know who Mike Brave is, Mike is actually one of the foremost experts in use of force. What's up, Riley? And hopefully you'll see, unmute your mic, right? I see it. It's still muted on my end. There we go.
Hey, can you hear me?
Loud and clear.
Hey, how's it going?
And good.
Good.
Hey, I'm a cop in California. I love your show. I always bring your stuff for briefing. And I had a quick question pertaining to a search of a vehicle upon a illegally parked vehicle and a Muni code violation.
Okay.
So I'll give you kind of the layout. Like approximately 3 in the morning, there's an illegally parked vehicle. Subject inside sleeping. In our city, that's a Muni code violation. Technically a misdemeanor. We're not gonna, we don't arrest for that, but that's like our PC for detention.
Yep.
And upon approach, contact this guy. Not talking, zero talking. It's okay, right?
Yep.
Ask him to step out of the vehicle to speak with us. He opens the door, slams it, goes and reaches. He's sleeping in the back rear passenger seats. Reaches super quickly into into a center area into a bag. From there, don't even pull him out of the vehicle, but like make sure he knows, like, hey, you got to step out, go hands on. While conducting a pat, he furtive move. Well, he jerks away while conducting that pat search.
Yep.
So put him in cuffs. Officer safety. Put him on the curb.
Yep.
From there, still not talking. At the time, I ran it by my WC and everything like that. Like, hey, he's committed a Muni code violation. If we want to cite him, he's not giving us any information. From there, and we've explained to him like, hey, it is a Muni code violation. It's arrestable if in our city if you don't provide ID. So that's kind of like the layout. But we're not going to do that. I ended up conducting a search of the specific area of where that subject was reaching for. Is that good to go as far as without no consent? I believe that he was reaching for a weapon.
Yep.
And I know I could articulate that all day.
Yep.
Do you see any issues with that? Do you think that's good to go? That's my question.
All right. Look, I'll take the first one, Mike. First of all, what's the rules of engagement? The rules of engagement is this is a protective sweep of the vehicle. Michigan versus Long is your case,
Okay.
which will basically apply Terry pat down rules to motor vehicles, right? In a sense, right?
Okay.
Sometimes cops say they frisk vehicles, but I think that's getting a little weird with vehicles. I don't frisk them. I sweep them for weapons. But regardless of the language,
Okay.
I'm making a joke here. But the point is that do you have objective reason to believe that the person was going for a weapon or could access a weapon and put you in danger while you're conducting your business? We also know that applying the facts to the law, right?
Yeah.
Do you have, what reasons do you have? Number one, and was it late at night?
Yeah.
You're all alone?
Yeah. Yeah.
He's acting, I'm just kind of repeating these, but he's acting aggressively. Also, is it in your experience, you don't have to say yes or no to this or say yes to this, but is it in your experience that a lot of transients, people that live in the cars, actually do have weapons for self-defense because they are in a vulnerable position oftentimes?
Yeah. 100%.
He also was lunging towards the vehicle. He's being non-compliant in many ways. He's being kind of weird by even the violation he's suspected of is extremely minor, and he's acting like he's being accused of bank robbery.
Right.
Yeah. So look, you're totally good to go. And now it's not the lunge area. That's one thing I think you said. You said you searched that area where he was reaching. Is that what you said?
Yeah. The only we stayed to the specific area to where he reached, nowhere
All right.
else.
All right. That's a restriction that you're placing on yourself. That's not what the law says. The law says that if you have
Okay.
these, and I'm just being just
Yeah.
educating, right? The law says that Michigan versus Long says you can search the basically the passenger compartment where they can access weapons. So do you think they can also access a weapon in the look? I'm not telling you shouldn't have searched that place first.
Yeah.
I'm just telling you that if you also believe that there could, if you have reason to believe that there is a weapon in there, and you can look under the seat, you can look in the glove box, you can look in a
Yeah.
bag if it's accessible. So the point is that I think you use good judgment here. It sounds exactly why they have this rule. It's reasonable suspicion level. It's not probable cause. It's a very low standard. It's objective facts, and I'm good to go.
Sweet.
As far as him not identifying himself, obviously you got to cross that bridge. You do have the authority to arrest people who will not identify themselves in California, as you know, in order to
Yeah.
receive a citation, because otherwise they walk away scot-free. Mike, anything to add?
You touched on it just a little bit, and Riley, you said for yourself, "Hey, we started where he was lunging towards." Let me ask you this, Anthony: don't you think that in the eyes of the courts, they like that? They like, what you're concerned about was where he was reaching. I think
Oh,
in
of
the eyes of
course.
the courts, they like that you went there first because that's where
Oh, okay.
your articulation was for the concern at that point in time. But like you said, it allows you to wherever else is accessible. But I like that you started where you did.
Yeah, and I also think tactically it makes sense too, because if that's where he's going for the weapon, let's neutralize that first, and then we can work our way around the rest of the car. And look, and feel good about your cases. If I'm like, no, that's the only place he's going, I'm not really worried about anything else, then and I don't want to search anywhere else. It's dealer's choice. I mean, but the law is in your favor, so good job.
Yeah. All right.
Um,
Thank you, guys.
Before you go though,
Yeah.
your peers are saying, does the use of handcuffs mean no longer have access? That's a great question, and Mike is going to answer that.
Well, when we talk about Michigan versus Long, I think there's some case that talk about the handcuffs. Yes, sometimes we put them on just to detain people, and then we take them off and release them after cited. So sometimes they're released back to the vehicle. And also there's discussions out there, and we've all seen where handcuffs are not foolproof. See, people can slip cuffs, they break.
Yeah.
I've seen those videos where guys in prison can snap even the
Yeah, those old ass cuffs, especially
yeah,
the
yeah, exactly. So yeah, there's that's a factor, something to consider, but it just articulate why that there's some
he's not
circumstances.
under arrest.
Yeah, exactly.
And in fact,
Awesome.
just Riley, and actually, not for you necessarily, but for Joseph, that whole issue about being restrained but being later returned to the vehicle was specifically listed in Michigan versus Long. So that's not a deal killer to any degree.
Okay.
All right. Cool.
Awesome. Thank you, guys.
Riley, just email. Richard will put his email, but if you want to, do you want a book? You want a search and seizure book?
Yeah, I would love one.
So,
All right,
yes.
we have one for California. So email Richard at bluetogold.com. He'll put the email in the chat and say, hey, I asked the question on the show tonight, and we'll send you a book. All right.
Great.
Give me one more thing, Riley, before you go.
Yeah.
And I know we're trying to be quick about this here. Just because you have somebody step out of a car, everybody out there, doesn't mean you automatically get to frisk the vehicle, sweep the vehicle before you put them back in. All right.
Right.
That's it. Just 2
Yeah,
cents there.
yeah.
That's
Got
yes,
it.
good point. Good point. Okay, now let's Rick, tell me who's next, but we're going to be taking we're going to knock out a couple of written questions real quick. So this is a cop in Illinois. He says, my agency recently began an unwritten policy around parole searches. They are saying we need to ask permission to conduct a parole search. Josh, do you have the case on this, Josh? From my buddy from is Josh here, Illinois? Okay, so Josh, anyway, if he's here, he may have the case on this, but permission to conduct a parole search from a person that's on parole, meaning, okay, we want consent search. If they do not consent or refuse to allow us to do it, they said just release them and call their parole officer. Okay, well, that's not the law in Illinois. Okay, so I guess Josh is not here, but I'm going to tell you what the case is. I meant to pull this up before we got going, but I just didn't have time. So let me just pull up Illinois real quick.
So we're talking about a Fourth Amendment waiver? Is that what
Yeah.
we're talking about? Oh, okay. But asking them if we can search them under it? Interesting.
Yeah, so look, so he's on a, but I think here's the problem though, Mike. So what's the rules of engagement? Okay, under the Supreme Court case Sampson and court cases Sampson and Knight, the U.S. Supreme Court basically laid out the framework for parole searches, but they have they have been applied to probation as well. But basically, what the Supreme Court said that parole is another form of custody in a sense. It's like, yeah, you're still serving your time, but you're going to serve it in the community.
Right.
Therefore, there's a very compelling penological interest to conduct these warrantless searches. I shouldn't say warrantless searches. It's even better. Suspicionless searches. That's the key here. Sampson says that we can conduct suspicionless searches under just because they're on a Fourth Amendment waiver, right? Okay. Now, not every state is strictly a Sampson style state. I mean, California is, and I got to tell you, I'll tell you, I didn't think any other state was more. I'm not aware of any other state that was as far reaching as California, that they can just stop people and do suspicional searches as long as it's not arbitrary, capricious, or harassing. But come to find out, Illinois is one of those states that doesn't require reasonable suspicion or.
But no, Nevada's not. So,
Nevada is definitely not. In fact,
yeah.
Nevada is, a little bit more restrictor. He
Mhm.
say, look, not only do you need some reason to believe they're violating the terms, that's an NRS, but they also have to be done at the behest, really, of P&P, parole and probation.
Yeah.
Now, police can be the agent of P&P, but they have to kind of start it. Right. So, but not Illinois. According to People versus Wilson, a case from 2008, Illinois Supreme Court. So that's good. They said
Mhm.
no reasonable suspicion was required for a warrantless search of a person who was on mandatory supervised release (MSR), and therefore this was a search of their house. So for my cop in Illinois, that's incorrect. But I'm not your boss. I'm not your legal advisor. If for some reason they don't like it, but if you want to show them some case law, show them People versus Wilson, Supreme Court of Illinois, 2008. All right. Okay. Now, who's up next, Rick? Is it Mike? No. Yeah, Mike. Okay. All right. Another Mike. What a
Lots of
what,
mics.
what a popular name. What a popular name.
And Mike. There you go. I'll bring in the mic.
What Mike? Okay, there he is. Hey, Mike.
That's a great name, Mike. Mike Bliss.
His mic is all jacked up. Mike's mic is jacked up.
Mm.
Yeah, let me turn off my Bluetooth. Can you hear me better now?
Now we're talking. Now we're talking.
Sorry, I was going through my hearing aid. So hey, quick question. So I work in Kansas. Missouri state line is 2 blocks away from me to the east.
Mhm.
We had 2 hit and runs from the same vehicle coming down our main roadway there, and he ended up in Missouri. Casey Mo ended up finding him. I investigated the 2 hit and runs. I went to where their location was at. He was still in the vehicle. He got transported to the hospital, was found with PCP and a firearm on him. I let Casey Mo take that part because that's their jurisdiction. I was going to apply for a blood draw search warrant. The question came up of whether or not the state line mattered. So we didn't do the blood draw search warrant. He actually consented to a blood draw. So I went and got a blood draw from him across state line. And then there's some other questions of whether or not I was legal to do that. Because I was across my jurisdiction and across state line.
All right. You want me to answer this, Mike, or you want to take?
We spoke about jurisdictional boundaries before, and okay, obviously the accidents took place in Kansas, and then you've got other charges in Missouri. But yeah, I'll let you, since you got a little bit of knowledge on that one.
Look, first of all, this can get a little complicated, Mike, because there could be some interstate compacts involved here, mutual agreements, and all this kind of stuff. So there could be some monkey wrenches in this. But let me just kind of tell you what I think is kind of going on here. And again, I'm not going to have a lot of certainty here because this would take some legal research to know what the real answer is. But let me just kind of tell you what normally happens in these cross-border issues. Okay. Number one is, obviously you have hot pursuit, right? So you chase him over the state line, right? So we got that. Or
Yep.
did he? Yeah. Okay. So we crashed out, and then so the warrant issue. The warrant issue. So how would you plan to get that warrant? Would you plan to apply for a judge in Missouri or Kansas?
Well, initially I was going to go through Kansas, but then I was like, well, wait a minute, we're going to need a magistrate in Missouri.
Correct. Your Kansas judge has no jurisdiction in Missouri. So what happens here? There's one of 2 ways to do this. Number one is to apply for a warrant in Kansas, get that warrant, then you're going to have to what's called domesticate that warrant in Missouri, which basically means that you're going to have to get a cop. You're going to have to get a person who's authorized by Missouri law to be an affiant. Okay, that can sometimes the affiant only can be a peace officer, like in Nevada, it can only be law enforcement. In other states, it can be a citizen. You can actually be an affiant in some states. I don't know the answer in Missouri, by the way. But also sometimes, prosecutors can be like, affiants, I believe. But the point is, you're going to have to, in order to domesticate a warrant, you're going to have to find somebody in Missouri who's authorized to write affidavits. They're then going to incorporate your probable cause by reference, and then they're going to submit that warrant to a judge and get it domesticated. Or you just verbally, basically describe, or in writing, you go to a Missouri cop and you say, hey man, I need your help. Like the Missouri trooper, I need your help. I need a warrant on this guy. And they just do it they just take your probable cause, right? Or their own probable cause, whatever it is. And they get the warrant. And then there's a term, and in the warrant, you apply for a turnover order. So you basically apply, you ask the same judge, hey, not only do I want to take blood from this guy, Missouri judge, but I also want you to authorize this Missouri cop to give me the evidence so I can take it back to Kansas. That's pretty much what happens in those cases.
Gotcha.
The next thing is consent to search. There's no issue, whatever, that I can see here about the way that went down. At the end of the day, consent is consent, right? The consent is three things. Did they voluntarily give you consent? Yes. Do they have the authority to put a needle in their arm? Yes. The scope of the search is whatever you ask for, right? So
Yes.
I see no legal hurdle about asking for consent to get that blood and bringing it back to Kansas. Was that in essence what your question was?
Yes, exactly. Yeah, so there was some pushback on that one, and I was like, well, he gave consent, so I think we're good.
How can you be bad? I mean, you know what I'm saying? Like, if I'm a cop in Nevada and I fly to California and I'm working a murder case, and part of my evidence is that he wore certain shoes during the murder, and I go to his house and boom, there the shoes are that I think I can see them on a plain view. But if I say, hey, let's say I'm not sure, right? Let's say I don't have probable cause, but I have reasonable suspicion. Hey, can I take your shoes? He says, yeah, you can take my shoes. You can take them as evidence, what I'm saying? Like it's there's no case out there that says you can't do that. There's no case that says you can't ask for consent across state lines. That's the easiest one to answer. The domestication and turnover order gets a little more complicated.
Sounds
right.
good, guys. Thanks so much. Yep.
And then email. Do you want a book?
Yeah, I'll get one.
Email richard@bluetogold.com. Okay, and tell
Awesome,
him just be specific so he knows why you're getting the book. All right. I asked the question. Cool. See you, Mike.
Awesome.
2 second story. When I was at the DEA task force, we had a wire case. We had a couple kilos of cocaine that was related to our case. Our crook lived out here. My partner and I drove down to San Bernardino, ate lunch, picked up 2 kilos of cocaine, and drove it back to Vegas. So that was a fun drive, cruising with 2 kilos of cocaine.
On duty? You're really not
Oh yes, by the way, on duty.
I mean, I'm not, I don't know if you're gonna take it as a compliment or a derogatory, but you actually look like an Italian mafioso right now. I mean,
I don't.
it just you kind of have that vibe going, man.
That was fun.
All right, Rick, put Andrew to the list. All right, so I do want to answer a question real quick. Hold on 1 second. Somebody asked a question in chat, and I actually do have the answer. There it is right there. Okay. Shannon says, can a parole search that yields federal level drug offenses be suppressed in federal court because the probation cost reasonable suspicion standard is less? Okay. So Shannon, I think what you're saying here is that if an officer searches something okay. Yeah. There we go. Let's turn that mic on. Exactly. Hold on. Boom. There's actually a lot of Shannons there. Hopefully I picked the right one. There's like 3 Shannons. So I think you maybe shared the link, but there's 3 Shannons on here. Did I get the right one?
Oh, she's Shannon with 2 ends. We know a Shannon with 1 end.
Okay. Did you see the mic? Can you ask the question? Or we can discuss this?
Well,
see. No, I just did both of them. Just see which one is. Because there we go.
Oh, there we go.
Hey, Shannon.
Can you hear me?
Yeah, I can. What, are you driving?
Oh, I don't know. I got a new laptop and have been having technical difficulties.
No, it's okay. So look, here's how I read your question. You tell me if I'm wrong. If we have a search, a probation or parole search under state law that is not necessarily in compliance with state law, can we still use that evidence in federal court? Is that what you're saying?
So we have some cases here to where we have the probation conditions. So we have the conditions. It was a good probation search. We didn't need a warrant for it. And then the case ended up becoming like snowballing into a lot bigger case and being picked up by the feds. But they're trying to suppress the evidence because it was a probation search. And so I think that like the suspicion standards were different because we don't need, like you said, like we don't need warrantless. We don't even need we can do suspicionless searches. And so it was
correct
on our end, but they're trying to be suppressed in the federal court.
Okay. I got your case. So if the case goes to federal, look, at the end of the day, did the local police officer, did the state police officer violate Sampson, right? Did they conduct a search, a warrantless search, a suspicionless search that violated Sampson? And it doesn't matter if it violates state law. What matters is to violate the Constitution under Sampson. And the answer is probably no. Your case is U.S. versus Braggs. It's a 2021 case out of the Second Circuit, where, and I'm gonna write this in the thing, okay? So you can kind of see it. I don't know if you're driving or whatever, but U.S. versus Braggs. It's a Second Circuit, and it's 2021. Basically, what the court said is, look, even if you need reasonable suspicion at the state level, or even if only the P&P, the parole probation guys, can conduct that search. Well, that's not what the Sampson says. Sampson says we can do suspicional searches as long as there's a Fourth Amendment waiver and it's for the penological interest and so forth. So even if it violates state law, it doesn't violate the federal law. It's coming in federal court.
Oh, okay. All right, so it should be good. That's really helpful because we've got, I think, 2 cases going on where it's trying to be suppressed right now.
All right. Well, hopefully that helps. If you want to give somebody that case, that's the case to go to. That is in my view, the seminal case on this particular issue, because this doesn't come up very often, but it is the seminal issue on that case. Okay. You're welcome. All right. So we're going to move on to another question. So the next question is from an officer in California. He says, look, one of my officers on my shift mentioned conducting a probable cause search, right, in quotations, of a person for contraband. This was not a search incident to arrest. The person's not getting arrested because people in California do not get arrested anymore. They get warnings for murder. It was not a search based on a Terry pat down. We kind of no playing field, he says. Mm-hmm. And I don't see how the individual could be arrested absent finding contraband either, meaning okay, look, so basically he says, look, he says, I do not buy the argument that exigency becomes the exception because it would be too inconvenient to get a warrant from a judge. I'm in California, if that matters. Okay, what is, okay, look, we know that in California, these drug offenses, a lot of them are cite and releases, right?
Right, yeah, there's no actual custodial arrest, yeah.
There's no custodial arrest. So what is this poor officer in California to do, Mike? Let them go?
I've got your answer. When you subpoena them from court, tell them they got to bring the evidence.
Deuces Tukum?
Yeah, there's your answer, right? Because every good crook's going to bring what they're supposed to court. Wait, no way. I'm sorry. They might not even show up for court.
Look, you're right. Hey, look, that's the answer. No, that's the answer. I don't know why you're being so funny, but just tell them, hey, I can trust you, right? Look, I can't search. Okay, I'm at the site. Look, I know you have drugs on you. Have a couple. I have probable cause that you have a couple grams of meth on you because you kind of told me you have, whatever it is. But look, I can't search you. So please bring that couple grams into court, but make sure it's an evidence bag because they might arrest you for possession. They may understand why you're bringing the drugs. Show the Dukas Tukum and also the 2 grams at the same time so you don't get arrested by the courthouse.
Exactly. Yeah, I love it.
Okay.
Or you could call it exigency.
So if that's not.
I know he said he's not, he's not, what did you say the wording was? Something about he's not buying the argument, I guess.
Yeah.
What's your alternative? Again, it doesn't seem like you have an arrest power in that. And then, it depends how long it take you to get a search warrant to search this person's pockets for that evidence. That might be a de facto arrest anyway, depending on how long it takes you to get that arrest there. And there's a few cases out there. I think there's a case, I think Colorado, somewhere where it's marijuana. And, they weren't going to arrest this guy. He was going to cite and release, but, they had, probable cause that there was evidence on him, specifically marijuana. And they, we talk about like a specific and targeted search for that evidence to recover it. Because if not, again, when this person knows, hey, I'm going to cite you for this stuff. So they know you're onto them. They know that you have played
a motive.
Yeah, and there's a motive to get rid of that evidence. And again, all jokes aside, you're never going to see that stuff again if you don't do it now.
The ultimate, there's only one search or seizure that's prohibited by the Fourth Amendment. What's that?
Unreasonable ones, my friend.
I mean, look, I know that we just can't go to court and say, but you're wrong. I thought I was being reasonable. But can we agree, Mike, that when you look at a 30,000-foot view of the situation, what seems more reasonable to you? We have probable cause that this guy has methamphetamine in his backpack or whatever. What sounds more reasonable? Doing a targeted search just to grab that drugs and kick him loose with a citation, or hold him on there. Handle it right there, or B, take him to jail and let him eat some bologna sandwiches, or C, hold him on scene for 2 hours for a warrant? What do you think is more? And by the way, but this cop might say, well, Anthony, it doesn't take us 2 hours to write a warrant. Well, here's the deal. These rules have to work for everybody in California, not just for cops with sophisticated warrant systems. What is the court to do here? What's the most reasonable thing that you think the cops should do here?
Handle business right there and just articulate their probable cause, articulate the exigency, the urgency to handle it now, and send them on their way.
And also, just so you know, I know people may not agree with this, but this is what one court said. Part of the agency is actually kicking them loose. There is you want to get rid of them. You want to kick them loose. You want to go back in service and start shagging the next call. That is part of the agency. That's part of the urgency to handle the situation now. I know it's kind of not like it's kind of weird because you're like, but there's also a case right on point. It's called United States versus Pope, Ninth Circuit. So we're in California, 2012. What happened here, this was a case when marijuana was illegal in California, but it was still cite and release.
Great times back then. Great times.
Yep.
Great times.
It was good times. And so the officer had probable cause that a particular passenger had marijuana in his pocket. He then searched the pocket, recovered the marijuana, gave him a citation, and released him. And the Supreme Court, the Ninth Circuit said agency. Okay, so there it is. So United States versus Pope, Ninth Circuit 2012 is your case. Okay, let's move on to the next person, Andrew. Andrew, okay. A lot of Andrews today here too. Here we go.
I'm the only one with the messed up last name though, Anthony. So
you definitely do not have a common spelling, brother. But I tell you, man, people probably mess up my last name as much as yours, man.
I will say
I'm
though,
not tired of being Bendejo. I think it's insulting at some point.
it's got USA right down the middle of it, so it's pretty patriotic.
That's awesome. What you got, my friend?
I like it.
A lot of times I'm going to ask you guys, because you guys have years of law enforcement experience, not only legal experts, but you guys have years of law enforcement experience too. Me and my coworkers, we had a little conversation the other day and about consent on searching a vehicle. Now, they thought that this was maybe towing the line of coercion, but I don't think it's really coercive. So let's just say you stop a car, you go up there, you make contact, you ask a couple questions while they're finding their documents, and you say, do you have anything illegal in the car? And they reply, no, of course. And then you respond back immediately with, well, then you wouldn't mind if I search your car now. Now, would you? And just see how they react. I don't think that's coercion, but they were thinking that it toes the coercion line. I don't think that toes the coercion line. And I think it's a good question to see that nervous behavior. I've seen it a lot of times in my experience asking it that way.
What state are you in?
I'm in Kentucky, land of the free.
It's pretty free, right? Almost as free as Idaho. So what do you think, Mike?
First of all, Andrew, you got to get into country music, my friend. I think you got to get into some singing. That's a country voice right there.
He does have a radio voice for sure, a singing voice.
Exactly right. You know what? It's not coercive at all. You're still asking. You're not leaning on him. You're not continually, trying to get him to change his mind or anything. And consent is all about asking a question, and you ask that question. Hey, do you mind? Careful with "do you mind" though, because that can be confusing sometimes. We've got a funny video in one of the classes we teach on "do you mind." Sometimes people aren't sure what the answer. Yes, I do mind, or no, I don't mind. But we always, maybe a little bit more to the point on that for sure. But no, I don't feel like it's coercive at all.
It's not coercion. The definition of coercion is overcoming a person's free will, right? At the end of the day, simply asking a person, "Do you mind?" or what I say, Andrew, is because the "do you mind" can be a little, as Mike said. But what I ask is, "Hey, okay, would you have a problem of me searching your car to kind of confirm that you're telling me the truth?" Because a lot of people out here kind of lie to police and so forth. I'm not saying that I ask this all the time. I have a reason for asking this, usually with reasonable suspicion. But but it's kind of similar, right? At the end of the day, that doesn't overcome their free will. The one issue I will tell you, Andrew, that can come up, that's a good argument, it's not frivolous, is that you can ask for consent in Kentucky without reasonable suspicion, right? Some states don't allow that on vehicles. New Jersey, New Mexico, Pennsylvania, Washington. Kind of your typical blue states, but one thing that can come up even in a red state that more conservative is that you're taking time out of the stop to ask an unrelated question. There is no case law out there that says you cannot ask for consent as a matter of routine. There is no case. In fact, the Supreme Court, was it Schenkloth? or Bustamante, but either one said that asking for consent is not a search or a seizure, right? But the one thing that we're seeing more and more is the argument that, hey, I call it selling consent, just taking a lot of time with this consent issue. If they say no, we just move on. And if you're going to take a lot of time to sell it, persuade it, whatever, which is not coercion, but they can come up with like, okay, do you have reasonable suspicion? No, well, you're taking like 40 seconds to ask for this consent. Some courts may want you to move on. Trey, I do not believe that Louisiana requires reasonable suspicion for car searches. I'm actually pretty positive they don't, but I can look that up if you want. Andrew, does that answer your question?
Yes, sir. Thank you very much. I appreciate your guys' input.
All right. Email rich@political.com, okay?
Yes, sir.
Whoa.
Thank you.
And get a book.
Thank you.
There you go.
Nate, you're welcome. All right.